What's up, everybody? This is the informal brief that I submitted to the Nevada Supreme Court that the state did not respond to, ultimately forfeiting the case, and may be treated as confession of error due to Nevada Rules of Appellate Procedure 31D2. So NRAP 31D2 is the rule of the Nevada Supreme Court in which submits this as confession of error. By them not responding, they're ultimately agreeing that it's true. Obviously, as you will see, if this stuff was false and I was lying and none of this stuff was accurate, of course they would have defended themselves against this. So, yeah, you guys might want to hold your jaws together listening to this. This is part one. This is my statement of facts. I will do a recording right after this one for the arguments and the conclusions. All right, here we go. Statement of facts. Introduction of state's intrinsic fraud. On February 19, 2015, appellant Eric Nowsch Jr. was taken into custody by police for questioning after smoking weed for approximately 15 minutes while being monitored by the same police who took him into custody without drug testing him or placing the appellant in detox. Instead, Detective Clifford Mogg, the arresting officer, and his partner took advantage and cut the audio off in their car and coerced Nowsch into giving an intoxicated confession on their way to headquarters. Nowsch denied any involvement for over an hour before giving a 5-minute confession and being processed for a list of charges at Clark County Detention Center. 2 days later, Nowsch was finally drug tested and tested positive at the maximum level of intoxication. On March 6, 2015, Nowsch had a grand jury indictment hearing in Justice Court where his innocence was argued by Justice Judge Conrad Hafen. The jurors attempted to indict Nowsch on illegal evidence, the intoxicated confession, and ignored eyewitness testimony from Crystal Myers, the victim's daughter, stating, "I know Nowsch. He was not there. I'm 100% positive. I would know if he was there." Judge Hafen postponed the indictment proceedings by immediately filing a court motion to dismiss all Nowsch's charges, release Nowsch from custody, and close his case. The state illegally took the indictment to the district court and had district court judge David Barker close and open a pending court motion to dismiss in justice court and transfer the case to district court per order. On March 9, 2015, Judge Hafen's motion was granted, and he ordered Nowsch's release from custody, closing the case and dismissing all charges against Nowsch. The state never appealed the decision or resubmitted any evidence to recharge him. Nowsch was never informed by anyone, including DAs, lawyers, or judges, and was never released. On March 20, 2015, the state took alleged co-defendant Derek Andrews' superseding grand jury indictment in district court and forged Nowsch's name on it. Also accepted evidence from Nowsch which he received from DA's key witness, Caitlin Christensen, admitting Nowsch's innocence. Between Augustus Claus and Public Defender's Office and appellant lawyer Christina Weldevelt, appellant's entire defense file was lost and never recovered, according to all lawyers' testimony on the matter. Discovery was court-ordered multiple times to give to me by Judge Villani, but it never was without consequence. Nowsch's lawyers told Nowsch, if you don't get your intoxicated confession thrown out, you'll get life without in prison. Augustus and Conrad Claus cited 2 case laws about drinking and driving as support to the Jackson versus Deno hearing to suppress the confession. Judge Villani denied the motion based on the inconsistent case laws cited by Augustus Claus. Nowsch rejected a second-degree murder deal twice before Augustus lied, saying the deal was for 5 years and gave Nowsch less than an hour to decide without a copy being present. On the day of the plea deal signing, Augustus refused to let Nowsch read the deal and told him where to sign. If not, he wouldn't get the 5 years. Villani had to inform Nowsch during the questioning to let him finish reading the question before answering, proving Nowsch was not paying attention during the plea deal. When Nowsch went to PMP, he found out what he really signed for and tried to withdraw the guilty plea immediately. Then Augustus Claus told him to ask a jailhouse lawyer for help and refused to file a motion to withdraw the plea deal. On December 22nd, 2016, Nowsch and his counsel requested an extension of time after only getting 13 days to prepare for sentencing and was not ready because Nowsch had no discovery. Villani denied the request and sentenced Nowsch to second degree with use and ran a separate case for assault with deadly weapon concurrent to the second degree murder. District Court Judge Jacqueline M. Bluth allowed the DA to serve subpoenas to my witnesses without participation from the district court clerks. She also allowed key witness to decide to show up or not without consequences. She denied my evidentiary hearing on December 11, 2024, based on Nowsch not having witness David J. Figler's testimony. Judge Bluth stated at July 15, 2025 hearing that Nevada Supreme Court doesn't know what they're talking about, and I am a party to the case after reviewing rejection of motion from Nevada Supreme Court. Linda Bell's voluntary disclosure clearing Nowsch of the March 20th, 2015 superseding indictment. Bluth stated she doesn't know why Linda would say that, and she's wrong. I was charged by her indictment on March 20th, 2015. Judge Bluth also allowed DA Christopher Hamner to admit on record he didn't know if I was indicted on March 20th, 2015 without ever making him clarify or answer whether or not I was. Due to that being the state's submission of how I was charged, it is critical that he answer that question. Nowsch's false imprisonment is approaching 11 years now. Eric Nowsch Jr. should be released immediately. If Nowsch is not a party to this case and cannot investigate it, then how can he defend himself against it either, as proven in the Nevada Supreme Court's rejection of motion dated 2/14/25. Also, please note that the transcripts of proceedings from July 15, 2025 hearing has been tampered with and is not accurate to the actual audio of the hearing itself. Please review, investigate the audio compared to the transcripts, as my statement of facts have some specific references that have been tampered with on records transcripts. Thank you. Please also note that the Public Defender's Office who represented Nowsch at sentencing informed him on multiple different phone calls through the prison's phone system that they never represented him for the murder case 304-831 or any of its charges. They only represented him for the assault case at sentencing under case number 306043. This is dated and signed by me on January 18, 2026, under penalty of perjury. Hey, what's up, everybody? This is part 2 of my informal brief. It's all submitted together as one brief to the Nevada Supreme Court. I just wrote these separately, or I'm recording them separately because I didn't have time within the 15-minute call to read it all at once. So this is the informal brief on the Nevada Supreme Court website from case number 91056, which is the screenshot that's posted on, or the documents that's posted on this page as well. This informal brief that I'm reading is once again, it was submitted on January 5th, 2026, and this is what the state did not respond to. So this is the argument and conclusion, the arguments and conclusions to the statement of facts I just read. So this is the rest of the informal brief. All right, here we go. Argument 1. Sheriff Douglas and Joe Lombardo intentionally and maliciously held Eric Nowsch in Clark County Detention Center against his will, constituting a wrongful incarceration in violation of Mr. Nowsch's 14th Amendment rights to due process. Claim 1. Here, on March 9, 2015, petitioner Eric Nowsch was wrongfully held against his will after documented evidence shows he was to be released from custody due to a sitting judge's ruling, that of Comrade Hafen, from the State District Attorney's indictment warrant filed on March 6, 2015. However, Petitioner was never released from custody or notified he was to be released by any state officials or counsel. District Attorneys David Stanton and Christopher Hamner and Steve Wolfson concealed all documents and information concerning Justice Court Case number 15F02612X, explaining all charges were dismissed. See Brady versus Maryland. Then, Transfer District Court Case number C-15-304-831 to a fraudulent superseding indictment warrant, adding a new additional charge of conspiracy to commit murder, substantially amending the original dismissed charges by adding a new charge. See Martinez versus State. This is the definition of malicious prosecution. See Torres versus Superintendent of Police. State officials Steve Wolfson, Stanton, on a superseding indictment warrant, beguiling the court and the public into believing petitioner was a cold-blooded killer. However, then District Court Judge Linda Marie Bell stated she did not make a substantive ruling in that superseding indictment warrant. In fact, now Supreme Court of Nevada Justice Linda Marie Bell and colleagues explained Mr. Nowsch is not a part of that indictment in question. This is a problem for the state of Nevada. Conclusion. Here, Judge Conrad Hafen ruling was final according to Nevada District Court Rules 18-1. See the State of Nevada versus Ruben Babian. Argument 2. District Attorneys David Stanton and Christopher Hamner violated petitioner's substantial right by the amendment of false information to reinstating dismissed charges causing plain error. Claim 2. The prosecutor's duty is to seek justice and to prosecute with carniousness and vigor, but must not use improper methods calculated to prejudice or to produce a wrongful conviction. See Berger versus United States. Here, petitioner argues that at his alleged co-defendant's grand jury indictment hearing, prosecutors Stanton and Hamner intentionally and deliberately allowed false testimony from Nowsch's arresting officer Clifford Mogg to be presented at the same grand jury. Judge Conrad Hafen dismissed all charges brought in an indictment against Mr. Nowsch in Justice Court. Here in District Court, Stanton and Hamner did elicit prejudicial information from Mr. Mogg when Mogg stated in pertinent part. And so I looked at that to see if that was comparable to what Mr. Nowsch drove, and it was, indicating that Mr. Nowsch drove the car an alleged co-defendant owned and was being indicted for. See Napoo versus Illinois. See also Morris versus Yeast. Petitioner doesn't even have or own a car, and there is no evidence that can support petitioner drove the alleged gold Audi. This constituted plain error. See Jeremias versus the state of Nevada. Because the prosecution used fraudulent information from Mr. Mogg to support their superseding indictment warrant, only to broaden the charges already been dismissed by Judge Hafen by adding the conspiracy to commit murder charge in a new superseding indictment warrant, along with all three previously dismissed charges in violation of Nowsch's due process, causing a fatal prejudice. See Martinez versus State. Conclusion. Here, Mr. Nowsch's charges were in fact dismissed, and the prosecution filed a superseding indictment warrant in wanton act, forging an innocent Nowsch's name, broadening the charges out of spite and ill will, and substantially amending the original charges. See Martinez. This constitutes plain error. Mr. Nowsch should be released immediately. Argument 3. Prosecutors David Stanton and Christopher Hamner did violate petitioner's 5th and 14th Amendment rights when they failed to disclose exculpatory evidence, that of Conrad Hafen's ruling dismissing all charges. Claim 3. Here, prosecutors Stanton and Hamner concealed Judge Conrad Hafen's ruling to dismiss all charges brought in petitioner's indictment. Petitioner argues that the 5th and 14th Amendment require the government to disclose specific types of evidence to defendants. The Due Process Clause requires the prosecution disclose, upon request, evidence favorable to an accused when such evidence is material to guilt or punishment. A Brady violation occurs when 1. Evidence is favorable to the accused because it is exculpatory or impeaching. 2. Evidence was suppressed by the government, either willfully or inadvertently. And 3. Prejudice ensured the standard is fully explained within Brady versus Maryland. See Brady versus Maryland. See also Kyles versus Whitley. See also Comstock versus Humphreys. And see also United States versus Bagley. Conclusion. Petitioner was never informed he was released from custody. This is material evidence. See Brady versus Maryland. Because petitioner could have notified his family to come pick him up. Instead, petitioner was blindsided by a fraudulent prepared superseding indictment warrant. See Martinez versus State. Argument 4. Attorneys Christina Weldeveld and David Figler failed to investigate the whereabouts of petitioner's defense file or evidence prior to the filing of petitioner's direct appeal, violating petitioner's Sixth Amendment's rights to effective assistance on direct appeal. Claim 4. Here, Christina Weldeveld and David Figler made a mockery out of the effective assistance required by counsel standard on petitioner's direct appeal as of right he is entitled. See Evitz versus Lucy. Both attorneys have a duty to make a reasonable investigation or to make a reasonable decision that makes a particular investigation unnecessary. See Strickland versus Washington. Here, counsels never investigated the basic rule of filing a direct appeal, that of having a complete record without limitations, such as certified copies of any criminal complaint, indictment, or information, including any amendments, all papers, motions, petitions, oppositions, responses, replies, orders, opinions, and documentary evidence, or exhibits filed in the lower court's transcripts of all lower court proceedings, all verdicts or findings of facts, conclusions of law, and decisions in the lower court's minutes. See Nevada Rules of Appellant Procedure 30C. Counsels never thought about investigating petitioner's case and records. After deceiving petitioner's mother out of her hard-earned money, petitioner was granted an evidentiary hearing on December 11, 2024 concerning his missing defense file. All attorneys involved in the case was subpoenaed by petitioner, and all attorneys testified one way or another to not having a complete file. See Strickland versus Washington. See also Evitz, including Christina. Conclusion. Evidence has come to light that Mr. Nowsch's second made and filed indictment is in fact fraudulent, and his name was forged to appear he was guilty of a crime he never committed. Evidence now shows the lower district court has sent an innocent then kid, now man, to prison. Christina and David were ineffective for not investigating petitioner's case and file. See Strickland versus Washington. Pursuant to 28 U.S.C. 1746, I declare under penalty of perjury that the foregoing is true and correct. And I dated and signed it, and at the bottom, I put a footnote. David Figler was a no-show to the evidentiary hearing. This is an indication of the conduct perceived in this case. So as everybody can see, these claims are very, very, very specific, very, very, very serious, and the state didn't even respond back to it. I think everybody should know when all of this fraudulent activity was taking place in the district court, which is the only place it ever took place at. on July 15th, 2025, when I just had the hearing for my writ for habeas corpus, which is what led me to being in the Nevada Supreme Court appealing the decision, I took that exact same thing that I just read in part one of the statement of facts and this recording with the arguments, and I did not rewrite any of this or do any of that. Only thing that was new was the statement of facts. Everything I just read in this recording was exactly the same thing. All I did was copy it and resend it to Nevada Supreme Court. I submitted this exact same thing I just read in this recording to the district court, and on July 15th, 2025, which is what I'm appealing now, the state responded to that and said that I was barred because of a deal. But now I submit it to the district court and they don't say to the Nevada Supreme Court, and they don't say anything. So I think that people should really take that into consideration, that if what I'm saying in this is not valid and there was mistakes or I was lying, you know damn well that they would have responded to that and defended themselves and argued against it. So the fact that they didn't say anything should tell everybody that I'm not making any of this stuff up and everything I'm saying is 100% valid. Otherwise, they would have argued against that, because that's very serious. Just for everybody who's not in this state or doesn't know about this state, Joe Lombardo at the time was the sheriff. He is now our Nevada state governor. Steve Wolfson is the head of the DA's office. You can't drive anywhere through Vegas without seeing their faces on billboards and on the sides of buildings, and they're everywhere. So these are the two people who run this state, main two people who run this state, the head district attorney, Steve Wolfson, and now the governor of the state of Nevada, Joe Lombardo, and these are the two people who are highly...
You have 1 minute remaining.
In my case, in my false imprisonment. So I think everybody should be fully aware of that and know that if I was lying or what I'm saying in these claims were invalid, they would have argued that and defended it, and they didn't. So I appreciate everybody's time. Please share this. Help me get this out there. Help get the world talking about this. This is serious. Not a psych patient. This is very real. And, I'm giving all the evidence. I'm proving everything. So I appreciate everyone's time. Please follow my page so that way as I continue to post stuff, you can stay updated and see what's going on as stuff happens. But anyway, I appreciate everybody's time. Take care out there. Thank you.